Appeal part heard in the matter of various Eateries Trading Limited and Allianz Insurance plc.
Yes,
Good morning, my lords. When we finished yesterday, I was addressing our ground 2, whether there is aggregation per premises or per insured location. And we'd looked at the judge's reasons for concluding that there was no aggregation per insured location. I'm now turning to why we say that that was the wrong conclusion. It would be helpful if you could have our appeal skeleton at core bundle tab 9 open, along with the policy, which is in the first supplemental bundle at tab 1, because I'll switch between the two.
I'll just get
So if I can start with, and it's appointed para 16 of our skeleton on page 96. We say that the definition of the SBIL, which we've looked at, it's page 33 in the supplemental bundle. Towards the bottom, definition 105. We say that that's a standard term in the Marsh Resilience form that is applicable to policyholders with single or multiple premises, and it would be present in the same form. And therefore we say the absence of any language supporting per premises aggregation in that definition is neutral. You have to look elsewhere to understand how the policy limits, which apply in the case of aggregation, will apply to situations of multiple insured premises. The next point, which is set out at para 17 of our skeleton, relates to looking at elsewhere in the policy, looking at the insuring clause. So if we go to the disease clause, it's on page 7 of the supplemental bundle, clause 2.3. And if we look at the disease clause, top right, notifiable disease and other incidents, it's 2.38, but at D, at the top of the right-hand column, it's about those notifiable diseases and other incidents occurring within the vicinity of an insured location, singular. And we see this as well at page 29 in the enforced closure, with the definition of notifiable diseases and other incidents. Definition 69, and if we look at Roman 5 at the top of the right-hand column, we again see or any other enforced closure of an insured location by any governmental authority or agency. So those are each expressed in relation to insured location singular. And we say it's therefore the case that cover is likely to be triggered separately in respect of each premises. For example, where the interruption was caused by the closure of the particular premises. And the fact that cover can be triggered separately in respect of each insured location is a pointer that the relevant limits were intended to apply to those locations separately. It would seem surprising that if the parties, having agreed a type of cover that can be triggered on a per premises basis, nonetheless agreed an aggregation limit on a different basis. Now the point that will be put against me is that the prevention of access clause refers to insured locations, plural. So if we look at that on page 30, you'll see there the reference in each of the definition 87, 1, 2, and 3, reference to in the vicinity of the insured locations. We would say that that doesn't change the analysis because prevention of access or hindrance of access or use is nonetheless a premises-specific peril that is triggered in relation to each insured premises separately. And we can see, for example, at 1, the example given there, the definition given there, is the discovery of a bomb or suspected hoax in the vicinity of an insured location. And at 3, the unlawful occupation of the insured locations. And those are likely to be premises specific and apply to one and not to collectively to all of the premises. So that's my second point. The third point relates to the factual matrix in relation to VE. Now that wasn't specifically addressed by the judge. He didn't address the arguments that had been made in VE's opening at paragraphs 142 to 147. At all. There was an element here of read across of the conclusions from the Stonegate judgment to VE. And indeed, before the settlement last week, this ground of appeal was also an issue in that appeal, one again the judge had given permission for. But the factual matrix as set out at 17.2 and 17.3 of our skeleton included the following points. The limits of liability, and you've seen this from looking at the schedule, were divided into two groupings of individual premises, and each of those groups had a different overall total limit and different maximum indemnity periods, 12 and 24 months respectively. If we look at the way the business was described, it's at tab 5 of the supplemental bundle in the schedule, page 73. It's described as operating a chain of Italian restaurants, providing eat-in and limited takeaway of food and beverages across UK sites branded as Strada, Copper Club, and above and below bars. So what that is providing, it's different types of hospitality venues operating at different locations under different brands. We say that that is a relevant pointer as well. In terms of factual matrix to per premises aggregation, if there is aggregation. It was also an agreed fact, and perhaps we can look at this at the same volume, but tab 6, page 104, and it's agreed fact 13. That various eateries disclosed material facts as part of its risk presentation prior to the renewal of the policy, which included a schedule of locations and the annual gross profit achieved at each location. The estimated annual profit declared to Allianz was calculated by reference to those locations, in that the figure declared for item 1 and item 2 insured locations was derived from combining the estimated annual profits of the relevant locations. So they were supplied individually and then grouped into two groupings, and the total was the total amount of annual profit from estimated annual profit from each individual location according to the grouping in question. The venues were in different locations across London and the South East, and they would have been affected differently and were affected differently by matters triggering cover. Mm-hmm. And VE has set out in voluntary particulars how the different locations were differently affected. Just to look at that briefly, it's at tab 18 of the supplemental bundle. Sorry, tab 20 of the supplemental bundle. Core bundle. I'm sorry, I'm in the wrong bundle. Tab 20 of the core bundle. And I was going to go to page 328. Yeah. And subparagraphs 8.1 onwards, just give an example. There's more detail in this, but just to highlight, at 8.1, Strada South Bank reopened on the 10th of July 2020. The reopening date was later than the lifting of lockdown 1 because it was a site heavily reliant on tourism, and it was deemed there was insufficient footfall to generate a profit during these extended periods of closure. We see at 8.3, Riverside works to convert Riverside from a Strada restaurant to a Tavolino concept. It started shortly before lockdown 1. It couldn't be completed until after the lockdown restrictions had been lifted, so that could not open until later in July. At 8.4, the 31 below location at Marylebone High Street was forced to stay closed until October 2020 because of insufficient footfall, it being an area that relies on high street traffic, and it also had a lack of outdoor capacity, so it couldn't generate a profit. 8.5 Strada Dockside, which didn't reopen until June 2021, relies on office workers and tourists around the St. Catherine Docks area. So they were all being affected differently by the restrictions that were being imposed. I'd like to go to one authority in relation to this, which is Corbyn and King, which is referred to in our skeleton. It's in Authorities Bundle 1, tab 8, and it's page 129. Page 129. It's part of the Corbyn and King judgment at tab 8 against AXA, decision of Mrs. Justice Cockrell. So volume 1, tab 8, and then the part I want to pick up is at 129. This was a non-damage denial of access clause. The clause itself is different from the one in this case. But I want to pick up the way in which the judge dealt with the point about her premises aggregation. And it starts on 129 in paragraph 223, just to highlight the competing submissions. The claimant submitted cover under the policy was in respect of interruption and interference with the business where access to your premises is restricted or hindered. Each restaurant was a separate business, carried on in different premises, and each restriction or hindrance interfered with a different business operated by a different insured. Accordingly, each interference led to a different claim, that being part of the policy wording. If AXA wished to prevent aggregation in circumstances where the same danger affected different premises in diverse geographical radii, it was open to it to draft the policy in such a way as to do so. It failed to do so. And then there are a number of other points, but just to pick up AXA's competing submission, paragraph 226 at the bottom. AXA
This was a composite policy.
This was, yes. But
This was a composite policy where each of the restaurants then in the Corbyn King group, and they've now, I think, been sold,
that's right.
was separately owned by a separate company.
Yes.
And that's set out at paragraph 9 in the judge's judgment.
That's correct.
So
and
you
that
can quite see why if there were separate insureds and separate companies owning each restaurant.
But that wasn't the only reason why.
It's on a per location basis.
I'm so sorry. That wasn't the only reason why the learned judge found in that
follow.
case that there was aggregation per insured location. And
Right.
it's the second reason that I want to take you to, because that
Okay.
we say is relevant here. But it was simply to pick up a 226 AXA saying that that it wasn't per premises aggregation. The business interruption section did not stipulate separate sums insured specific to a particular premises. The use of an aggregate limit suggests it's intended to apply to all premises and all companies insured. No individual premises or company has the benefit of a specific sum. And then at 228, the discussion section, there were effectively two strands to the argument on this point. The first was essentially a construction argument based on the wording of the policy, and the second was a legal argument derived from the fact that the policy was a composite policy. And then if we go to the next page, 131, paragraph 237, at 237 and 238, the learned judge identifies that each company has a separate interest represented by the restaurant or restaurants cafe which it owns. The policy therefore falls to be analysed as a composite policy. That's not an insignificant conclusion, because although it's not beyond the bounds of possibility that there could be a composite policy with a single limit which applies to all premises and all the claims, that would certainly not be the expectation in the context of a composite policy. And that's the Lord Chancellor's point. But it's this bit, this second ground, which is a matter of construction of a different policy, I accept, but it's the approach I rely on. One then moves on to the construction points. Here, the most powerful points and the ones which unequivocally support the claimant's position are the facts that, first, the policy refers to cover in respect of interruption and interference with the business where access to your premises is restricted. And the premises were in different locations and could well be differently affected by a danger triggering cover. Mr. Gruder QC's nuclear incident in central London would leave Cafe Wolseley at least untouched. Further, as he pointed out, closures from 2 suspicious vehicles, one near the Delaunay and one near the Wolseley, must be seen on any analysis as 2 separate incidents. And there's no logical distinction if it's the same car equidistant from the 2 premises, the 2 venues which closes both premises. The word premises points to each restaurant or cafe, and that distinction illuminates how a separation of interests may well operate, and that in turn points to separate limits. That then harmonises with the fact of different named insureds and the separate interests which underpin a composite policy. So I recognise it's a composite policy, and this isn't. But I say that the second ground of reasoning, which was a construction point, is one that is applicable and provides support for VE's interpretation. If I go back now to our skeleton, paragraph 17.4, which is in the core bundle, page 97. We say there that there is a substantial mismatch between the overall limit of indemnity, total value, and the limits applicable to an SBIL in the case of aggregation. So if we look at the schedule in the VE schedule, it's supplemental bundle tab 5, pages 76. We do also need to look at 94. I think my learned friend may have gone to it at page 97, but for the replacement bit, the endorsement, which replaced the bit at the beginning with 2 sets of estimated annual profit, 2 indemnity periods, and 2 sets of total value. But what you're getting in relation to this is you've got a total value which is based on estimated annual profit with a percentage uplift, which totals some 48.668 million, which is items 1 and 2 combined. Looking at page 97, that goes in at the top. And then we've got limits of liability being the total value, and then we have insuring clause 2.1 and then 2.3, and then we have some limits that are set out. The first 5 limits are actually for the full 48.6 million, any one SBIL. We then have different limits, including the one at 8 for notifiable diseases and other incidents of 2.5 million, any one SBIL, and then at 12 at the bottom, prevention of access non-damage, 500,000, any one SBIL. Now, in circumstances where the nature of the perils comprising the covered event is such that they can affect both individual premises in isolation or, in the case of a pandemic, all the insured premises, it would be, we say, surprising for there to be a single limit so substantially lower than the overall sum insured which operated across the premises. And that was the overall sum which determined the premium which was paid, and we've set out at footnote 6 of our skeleton the references in relation to that.
If you look at the first 6,
Yes.
accidental discharge down to investigation of crimes, they could affect either an individual location or the whole business, but it would be surprising, wouldn't it, if the £48 million limit was to be applied on a per location basis.
Yes, but looking at the mismatch between them,
You look at the obvious one, infestation. For
infestation.
example. That's unlikely to be at all the locations.
Yes.
And, you know,
There may be a degree of illogicality in relation to how these are set out. But the judge relied on the first 5 items to say, well, it must encompass all of the premises. And we would say, well, the converse also applies. When you're looking at the low limit of 2.5 million in relation to something that can affect multiple premises, it doesn't make sense to read that as applying across all of the premises. So what we would say is here you have a £2.5 million limit, which is 20 times lower than the total value for all locations. And the 500k for prevention of access is even lower. And we would say that the fact that that is so disparate indicates that it's intended to work on a per premises basis rather than to be aggregated across all premises. I accept it's quite difficult to understand why there is a £48 million limit for infestation, for example.
But if you take, sorry, I say if you take something which could affect
yes,
all of the locations, investigation of crime. So
yes.
let's assume that the chief executive officer of the whole company is accused of having done something terrible, and that causes the business to be shut down as a whole. It would, it couldn't possibly be that you get 48 million times 10 as your limit because you've got 10 separate premises, and if that doesn't work on a per location business, and you're simply construing the words any one single business interruption loss, then why are those words to be construed differently notifiable diseases?
My lord, we're not suggesting you would get 10 times 48 million. VE's case is that if one looks at limits of liability, it starts with the words being the total value. And the total value, as I said, it's not set out on page 76, but it's set out in the endorsement, is 48.6
Yes,
million.
because that's the profit of the business as a
So-
whole, with an uplift applied.
Yes. So what you're effectively getting, we're saying that that provides an overall limit, a cap on what would be recoverable, which makes sense because that is the estimated annual profit for all the businesses. In the case of business interruption caused by investigation of crimes, etc., that would mean you only had one limit because your limit is already at that total value, that being the cap. So it's not a case of 10 times 48. You get 48 as your cap. In fact, what you get would be the actual loss, which could be proven,
Well, of course.
which is, may well be a lot less than that.
Well, that's the cap.
Yeah, well, that's what we say is the cap. I'm going to come back to that when I deal with my next round of appeal, because that's where we get into issues about what is the relevance of the total value. But the judge relied on the fact that the 48 million was the SBIL for various elements, whether it's property damage or whether it's the business interruption specified causes, the list of 5 to begin with, to say, well, it must mean all locations. But we would say, well, but look at the 2.5 million. You've got something that could affect all locations, and it's 2.5. It's so much lower than the actual annual profit. And we would say that means that that limit is more likely to be intended to work on a per premises basis rather than across all premises. And we would say that whether an SBIL is premises specific or operates across the whole group will depend on the nature of the particular loss. In particular, it's going to depend on whether the resulting business interruption loss, which is what's insured under clause 2.3, is felt at the premises level or at the group level. And you can postulate a situation where some business interruption losses do not affect different locations any differently. So one example might be group interdependency damage. So destruction of a building, which is not an insured location, based on definition 39. So that's a situation where that may then affect the group without distinction between the individual premises. But there are others, and the ones that we're interested in are of that nature, are ones which will necessarily affect each insured premises differently. And we would say those are subject to a per premises SBIL limit. So you've got to look at the nature of the the peril and the nature of the loss and where it is felt. Turning now to the retention, which was a matter that the judge placed reliance on. It's at 18.2 of our skeleton that we deal with this. It'd be helpful if we could look at the retention itself in the VE case, because it differed from Stonegate. And that is at page 83 of the supplemental bundle behind tab 5. Now, in the VE case, the retention of 5,000 each single property loss did not have, there was not a retention relating to single business interruption loss. It was only applicable to single property loss, which isn't relevant here. So that was different from Stonegate, but is not identified as a material difference, but it's one we say is material. The words which follow the retentions, we say, are actually supportive of the proposition that SBILs affecting multiple insured locations do not constitute a single SBIL. The wording is where an insured has made a claim for a single property loss and or a single business interruption loss affecting one or more insured locations that arise from or are attributable to or are in connection with the same single occurrence, only one retention, being the largest applicable, will apply to all single business interruption losses combined. And we say that that wording seems to presuppose that there can be multiple SBILs affecting different insured locations. So we say that's a point going the other way. It's supporting per premises aggregation. It's not a point against it. And in our skeleton at 18.3, we note that the fact it's not a composite policy, that might put it beyond doubt, but we say that the fact it's not a composite policy isn't determinative. Even if it was composite, it wouldn't resolve whether the SBIL was per premises or for all premises, because each insured may own or operate multiple locations. I'm now going to turn to address one point that was raised against this ground of appeal in Allianz's skeleton. We could look at what was said about that. It's at tab 11 of the core bundle, page 116. It's paragraph 7.1. And it said that the SBIL wording is clear, it doesn't operate on a per insured location basis. That's the end of the matter absent a specific provision to the contrary elsewhere. Moreover, Allianz notes that where the policy intends to impose limits on a per insured location basis, it says as much. And then it gives an example. In the policy schedule, the sublimit for extension 1, capital additions and acquisitions, refers to sublimits per individual insured location. Likewise, the limit of liability in respect of insuring clause 2.38, supply chain and contract sites, is expressed as being £500,000 per entity or location. It would, in Allianz's submission, be inconsistent and unlikely that the policy draftsperson would have intended the SBIL limits to apply per insured location without saying so specifically. Now, their point is that because the SBIL, the policy doesn't, it contains clauses that operate on a per insured location or per location basis, but the SBIL limit doesn't, and therefore it would need to have done so. And clearly the draftsperson was alive to that. Now, in fact, neither of those perils, capital additions, acquisitions, supply chain contract sites, are actually subject to an SBIL limit. If we look at the schedule at page 76, you see at the bottom supply chain and contract sites, and over the page the unspecified entities or locations, 500 500,000 per entity or location. So no reference to SBIL for that. And then at 81, we have the sublimits schedule for the extensions. We have at extension 1, this is the limit of liability applicable to a single property loss and or an SBIL, unless the individual sublimit is expressed as in addition to the limit of liability. And then we see at extension 1, capital additions and acquisitions, and then automatic additions and acquisitions threshold, 2.5 million per individual insured location. So they are limits per location or per individual location. But on analysis, the reason why they're being dealt with separately is that they are not insured locations. So they need a bespoke regime. And when you look at that regime, it actually supports the construction that there is per premises aggregation. So if I go to capital additions and acquisitions, it's at tab 1 of the supplemental bundle in the policy, page 8.
Why does this help you? Because if Mr. Doherty is right about this, there being one overall single business interruption loss, all this is doing is saying, well, if you add premises, if you buy a new further and better restaurant, then it falls within whatever the limit of liability is on this hypothesis, 2.5 million, unless you've said that the limit is in excess of the limit of liability. And all it's saying is effectively the same limit applies as would apply to the premises that are already insured. And you have to have per individual insured location, because you might be adding more than one premises, you might be adding 5 or 6 or something.
You might.
It's basically the insurers saying, if you add stuff in, you get the same limit of liability.
But it's the same limit per individual premises.
Well, that's
It's
what
not
you say.
2.5 million per all of them. If I can just develop that point, I hope I'll show you why we say it's actually a point in support of VE rather than in support of Allianz. And my lord is right about the context in which this arises. If you look at extension 1 on page 8, it states that the policy will automatically include as property insured up to the automatic additions and acquisitions threshold, newly acquired buildings or assets and contents, and newly erected buildings from the date of their acquisition, erection or commencement of alteration, etc., during the period of insurance. So it's basically applying where VE newly acquires or erects a building during the period of insurance. And then at 1.2, in the event of the acquisition of a new subsidiary company of the insured, the locations and premises of that subsidiary company will automatically be included as insured locations from the date of their acquisition. So, as we've seen, the newly acquired or erected building is included as a property insured up to the automatic additions and acquisitions threshold, which is 2.5 million per additional property, as we've seen from page 81. It's per individual insured location. So you get 2.5 million for each. And we would say that there is no good reason why each newly acquired or newly erected building or premises would get its own limit of 2.5 million, but the existing buildings would all get a combined 2.5 million pound limit. Rather, the intention is likely to be for the new building to be treated in the same way as the existing ones, and thus we would submit each would have their own limit. The position in relation to acquisitions is neutral, because they become included, acquisitions of subsidiaries, they become included in the insured locations. So that brings them in line with the existing insured locations, and thus they have a 2.5 million pound limit. And we're back to the question of, is that per premises or is that across all premises? But in relation to the newly acquired and erected buildings, the fact they each have their own £2.5 million limit, we would say is positive support for our case that there is per premises aggregation generally. Same position applies with supply chain and contract sites. They're defined at page 34. Definition 111. They mean any maintenance and service premises, customer, contractor, franchise or supplier's premises, and other locations where the insured is carrying out a contract for the supply of goods and or services, and or any other specified premises. There are none specified here. And each of those definitions, if we look at maintenance and service premises, it's definition 60 on page 28. It means any premises to which the insured has temporarily sent property insured for cleaning, renovation, decontamination, repair and maintenance. Customer, contractor, franchise or supplier's premises is defined at 19 on page 23. Those you can see there are essentially the premises of the insured's customers, etc. Other locations where the insured is carrying out a contract for the supply of goods and or services, definition 75, means any premises not owned or occupied by the insured. And each of those sites, as we've seen on page 77, the schedule, gets its own £500,000 per location limit. Where they're unspecified. So again, it's not easy to see why insured locations would be subject to a global limit, but third-party locations are getting a per premises limit. And we would say, again, it's a pointer that supports VE's appeal ground, that the 2.5 million was per individual premises and was not intended to apply across all of them for the reasons that I've outlined. So, my lords, those are the points that we would rely on in relation to per premises or per insured location aggregation. And I'm proposing now to turn to our ground 3, which is not always one SBIL, for which permission is needed. Now, this is an issue which only arose in the VE case. And it's addressed in our skeleton at section D, page 99 of tab 9. Paragraphs 19 onwards. If I can take you to the answer to the preliminary issue, there's number 8 that is relevant here. It's at tab 14 of the same bundle, page 234. You'll see there the judge's conclusion, or the declaration arising from his conclusions, is that if there is a covered event giving rise to business interruption loss, there will always be at least one SBIL. Accordingly, the limits of liability are the amounts identified as limits in the schedule, including those applying to any one SPIL, such as insuring clause 2.38 and the prevention of access clause, subject to an overall limit. So there could be no recovery under the policy in respect of BIL in excess of 7.9 million for item 1 venues and 40.7 million for item 2 venues, irrespective of the number of SBILs, or in the case of 2.38A, premises or locations involved. And if we go to the judgment to look at how the judge dealt with it, it's tab 15 of that bundle, for bundle 259. deals with it from paragraph 74 onwards. And perhaps I can start at 76. The respective positions of the parties were these. VE contended that Allianz agreed to provide total business interruption cover of 7.9 and 40.7 million. Allianz contended the limit of liability was 2.5 million for the disease and enforced closure clauses and 500,000 for the prevention of access clause, and are not subject to any maximum indemnity limit. VE's case was based on the fact that in the schedule under limits of liability appear the words being the total value. Total value is not a defined expression, but VE contends that it's a declaration, it's a reference to the declared values, which have been set out under declared values business interruption in the schedule, and that is supported by the second paragraph under declared values material damage, that the declared values represent the total values of the various locations that have been declared by insured to the insurer within the location schedule. VE contends that Allianz's case gave no effect to the words being the total value. It's also submitted Allianz's case would mean VE would only be entitled to cover if it establishes an SBIL, i.e. if its BIL was in connection with a single occurrence, and that would mean if the court rejected all of Allianz's aggregation arguments, VE could end up with no indemnity. Furthermore, Allianz's case transformed the limits of liability into indemnity clauses. And then for its part, Allianz pointed out that all the various limits under the limits of liability for insuring clause 2.1 and 2.3 were just that, limits of liability. They're not sublimits, which are dealt with in item 4. By general condition 8 of the policy, the liability of the insurer was not to exceed the limit of liability specified in the schedule, and that included each of the limits of liability for business interruption loss, most of which were expressed as applicable, any one SBIL. Allianz further contended that VE misunderstood its position. It clarified it was not saying that without aggregation there would be no indemnity, and accepted that if there was a covered event giving rise to BIL, there would always be at least one SBIL. In my judgment, that concession must be correct. The limits of liability are clearly not intended as indemnity provisions and are not seeking to provide there can be no cover for a covered event unless there's aggregation of losses by reference to their connection to one occurrence. Equally, it appears to me that the specified limits are intended to apply to all claims made under each of the insuring clauses listed. And then the example given by reference to 2.35, whether there is aggregation by reference to an occurrence or not. Parties cannot have intended that that limit should apply if there was aggregation, but it should not apply, and only the much larger total value figure apply if it was not. As to the effect of the words being the total value, I'm inclined to think this serves as an overall limit, so there could be no recovery under the policy in respect of BIL in excess of that amount, irrespective of the number of insuring clauses involved and the number of SBILs involved. So the significance of the finding is that 2.5 million, the 2.5 million per SBIL limit applies even if there is no aggregation, or to put it another way, it's saying there will always be aggregation, there will always be an SBIL.
How does this point actually arise on the fact of this case, and why is it of any relevance?
I'm going to come to that. May I deal with that in just a moment, my lord, because I think if I can just deal with setting the context, it will fit in better. Our submission is that the better interpretation is that in the case of aggregated losses, then a limit of 2.5 million applies. But in the absence of aggregation, and I'll explain examples why we say there could be absence of aggregation, then the maximum recoverable BI loss in respect of each unaggregated loss, whether individually or collectively, is the overall limit of indemnity, the total value. If it's below the overall limit, and these are just limits, then obviously only the actual amount of the loss subject to proof is recoverable. Now, the only reason given by the judge at paragraph 80 is that the parties could not have intended that the limits would apply in the case of aggregation, but only that the much larger total value figure would apply in the absence of aggregation. Now, we've looked at the schedule already, and you've seen my submission this was what was the focus. It's item 3, page 76. Limits of liability starts with being the total value. And we were saying, well, that must have some meaning. It's under the heading limits of liability.
Sorry, hang on, which page?
Page 76, my lord. We were saying, and you can see total value defined top right. It's the wrong figure there because that's been replaced by the endorsement. But we were saying limits of liability being the total value gives you a limit of liability. And then you go on to look at whether there is aggregation, whether there is a single business interruption loss. And if there is, then you get the limit per single business interruption loss. So we were saying that the limits were not just what follows in the right-hand column with individual limits for individual perils, but being the total value was effectively that's your limit of indemnity. If there's no aggregation, you would get your loss up to that limit of indemnity. If there is aggregation, then you're limited to the amount set out per SBIL. Allianz's submission, as you've seen from the judgment, was that there was no overall limit. The only limits were the SBILs, and you got as many of them as existed, even if that exceeded the total value. So if you had 30 SBILs, you'd get 75 million, regardless of the fact that the total value was 49 million. That was the case that they were pushing. They were saying the only limits are the SBIL limits. Now, the judge accepted our point that the total value provides an overall limit. And you'll have seen from the judgment, it's not relevant to this appeal, that there had been a concern by VE that if all of Allianz's aggregation arguments failed, such that there was no aggregation, well, then is there any indemnity? Was Allianz going to say, well, we want the 2.5 million we've paid you back? And they said, no, we're not saying that. But we are saying there will always be an SBIL. And that's where the always one SBIL language comes from, in the last sentence of paragraph 79, and then the first sentence of paragraph 80 of the judgment, where the judge says, well, that must be correct. Now, our submissions on this are set out in our skeleton. I don't think we need to go to it, but just for your note, from paragraph 20 onwards. And the reason why we say that that's not correct is as follows. We say, firstly, there's a distinction between business interruption loss and single business interruption loss. Set this out, paragraph 20.1, page 99 of the core bundle. So what clause 2.3 of the policy does is it enables you as a policy holder to claim, as we've seen, the resulting business interruption loss. So that's your cover. It's for business interruption loss, called BIL. And that is in turn defined, as we've seen, we've looked at it already, it's definition 9 on page 23, as the reduction in turnover, increased cost of working, and or research and development expenditure. And none of those concepts are defined by reference to SBILs. The obvious inference is that not all recoverable business interruption loss also comprises an SBIL, a single business interruption loss. So we say the starting point is that VE is entitled to recover its resulting BIL, its resulting business interruption loss, whatever that is. And we say that that's consistent with the definition of the SBIL, which is on page 33 of the supplemental bundle, definition 105, which starts with the meaning at 1, all business interruption loss, business interruption costs, etc., that arise from, are attributable to, or are in connection with a single occurrence. And then we have the exceptions. So if all recoverable business interruption loss amounted to an SBIL, then why have a separate definition for SBIL? We say, and this is where I'm going to come to my Lord's question, we say that there is no reason to suppose that these losses will always arise from, be attributable to, or be in connection with a single occurrence. Because what if you have no single occurrence or event, but you have instead a state of affairs or an originating cause? How do you then get to an SBIL? And we've seen from the definition of cyber events that in that case, the policy is defining an SBIL as meaning single, in relation to single originating causes, not occurrences. And the definition of cyber event, if we look at it at this point, definition 20 on page 24.
Well, we're not dealing with cyber events, that's got a different limit
Nobody,
of liability. But the question I was asking you is it specifically in the context of these provisions, that's to say, clause 2.3, 8 and 12. What are the circumstances in which there would be some additional non-single business interruption clause or non-occurrence claim? Because logically, the whole point of, I mean, true it is that this point the judge makes, these sorts of provisions have to be dealt with on an even-handed basis, because where there are these sort of aggregating limits, they can be both in reference to aggregation clauses which by and large benefit insurers, or retention clauses which by and large benefit insureds. But here we're dealing with an aggregation provision which is really benefiting insurers, where subject to your location point, the insurers are saying the most we will pay for any claim in relation to notifiable disease is 2.5 million. Full stop. We're not going to pay any more than that.
any one SBI.
And what your submission entails is that although for the whole of COVID there's one occurrence, let's say, right, is that they only have to pay out 2.5 million. But if there's some other notifiable disease which isn't a single occurrence, and I'm not entirely sure for the life of me how that logically can come about, but assuming it does, and you had a claim for 42 million in relation to one of these premises, or the premises in that's not 42 million, it's wrong, but 40 million in respect of item 2, you can claim the whole of the 40 million. I mean, I follow that it's you know, factually extremely unlikely, but I'm just trying to test the logic, yes. Because instinctively one says the idea that somehow there's some free-ranging limit beyond the 2.5 million is doesn't sort of seem very sensible.
The total value limit, the overall limit, is the overall estimated insured annual profit. So it's not free-ranging in that sense. It's actually an estimate.
The total value is the estimated profit times 133%.
Yes.
The limits of liability under the policy are set out separately.
They are.
And they are not the total value. And there's nothing in this policy that says, I don't think, that you are is there an exhaustion provision that says you can only claim a total of 48 million overall? I don't think there is. If there is, I couldn't find it, but I may be
with the judge, I mean, this was our submission and the judge accepted it, that there was an overall limit of 48 million,
well,
if you combine the two, by reason of the words being the total value.
Well, I'm not sure he's right about that, because total value's got nothing to do with the limits of liability. Whether you look at page 76 or the endorsement, whichever it is, 94, it says there, because that puts in a different total value, because it divides up the 48 million, because I think what's happened here, I may be wrong, is that page 76 is just a mistake. The total value there shouldn't be 7 million, it should be 48 million odd.
No, that's correct, that was replaced.
And so it's replaced by the other one, which breaks it down.
Which breaks it down.
But it makes it absolutely clear that the total value and the limits of liability are two separate things.
Well, my lord, my submission is they're not two separate things by virtue of the words being the total value. But,
yeah, okay.
But in any event, you're talking about COVID. The SBIL definition requires an occurrence
Yeah.
for this purpose, not an originating cause. So it's not the pandemic. If it was originating cause, then one might well say, well, there's always going to be one. But
I understand. Right, so I'm just trying to test what the circumstances are in which you say, well, I have got claims where I can claim more than 2.5 million.
Yes.
In this case.
In this case, an example is because the judge didn't find that the single occurrence was each and every case of disease. The first aggregating event or occurrence that he establishes is the 16th of March instruction to stay at home. So prior to the 16th of March, you've seen that VE was suffering losses. Other policyholders were suffering losses. Greggs and Stonegate had losses. Stonegate's losses exceeded 2.5 million for that period. That is a situation where prior to mid-March, we would say there is no aggregation. The first single occurrence identified by the judge happens in mid-March. And the judge's conclusion doesn't give a clear answer to whether and why pre-16th of March 2020 losses should be aggregated. And I'm going to come back to that in a moment, but may I just deal with some context first? Because we say you could have a situation where you have a business interruption loss that's caused by two factually distinct but simultaneous perils. So you might have the coincidence of notifiable disease and an unrelated off-site utilities problem. Now, if it wasn't possible to disentangle the causative impact of each on the business interruption loss, given the fact that they happen at the same time, then neither would be an SBIL because the business interruption loss would not arise from the same single occurrence. And what the judge did in the Greggs case, in the context of an argument about loss and what loss was recoverable, was he distinguished business interruption loss from single business interruption loss. We go to Greggs at tab 19 of the supplemental bundle, page 582. It's paragraphs 40 to 41. And the judge says there it was in the context of an argument which was related to what losses were encompassed by the covered event as opposed to aggregation. But he said at paragraph 40, to recap, second line, BIL is defined in part as reduction in turnover. Reduction in turnover is calculated by taking the turnover of the insured's business and comparing it with the standard turnover of the insured's business as a whole, that being Greggs' business rather than Greggs Foundation. This way of defining BIL does not, however, indicate that there must be considered to be a single loss for the purpose of the limits provisions. Such an approach would be inconsistent with the fact that there is a distinction drawn between BIL and SBIL. Existence of the latter term and concept indicates there can be a plurality of losses which fall to be aggregated as one SBIL. Indeed, the logic of Zurich's argument in this respect would appear to be that there was one loss and one SBIL limit, even if there were two wholly distinct covered events at different shops, because the disruption to each will be reflected in the overall reduction in turnover of the insured's business. I regard that as clearly incorrect. And then at 41, more generally, I accept Greggs' submission that the correct approach as to whether its claim in respect of COVID-19 losses is limited is in the following 4 stages. If Greggs has incurred BIL, including reduction in turnover as defined, if that BIL has been proximately caused by interruption or interference with the business as a result of one or more of the covered events under clause 2.3, if that loss has not been proximately caused by an excluded peril, then Zurich is obliged to indemnify Greggs for that loss, save insofar as one or more of the limits of liability or sublimits place a limit on Zurich's liability. And I accept prior to stage 4, the policy terms do not divide the insured's loss into a countable number of losses and place limits on the recovery by reference to that number of losses. Any limit derives from the application of the limits of liability, including the limit any one SBIL, which incorporates an aggregation provision. And we say that that is difficult to reconcile with the judge's conclusion in the VE action, that there's always at least one SBIL, i.e. that the pre-16th of March 2020 losses would be capped at 2.5 million. And it's not a position that was taken by the Stonegate insurers for what it's worth, but I think it's worth looking at how it was developed in that case, that they agreed that Stonegate could recover all of its losses before the 16th of March 2020, not being subject to any SBIL cap of 2.5 million. And they put it on a different basis in their consequentials hearing skeleton and then at the hearing itself. But if we have a look at the supplemental bundle tab 22, page 679. Paragraphs 16 to 17. At 16.2.
Sorry.
I'm so sorry.
15.
Tab 22 of supplemental bundle. I think it's volume 2. Page
Yeah.
679.
679.
Paragraph 16.
671 for some reason. On the screen. 679. Yeah.
And at 16. Paragraph 16. And 17. At 16.2, at 16.1, Stonegate insurers accept on the basis of the court's conclusions on aggregation that the government action single occurrences found by the court on the 16th and 20th of March do not aggregate any claimed losses prior to the 16th of March. And Stonegate is entitled to recover all its pre-16th of March 2020 losses, subject to adjustment, etc. This has always been Stonegate Insurers' position. And then at 17, Stonegate Insurers' position is that this is the case because in this pre-government action period, there will be as many SBIL limits as there are covered events, i.e. occurrences of COVID-19 in the vicinity, and not because there is no aggregation and no applicable SBIL limits, such that the overall total value limit applies. Now, the position changed on that at the hearing itself, and we can see that at the prior tab, tab 21, page 636.
Yeah.
And it's page 49 of the transcript from line 18 onwards. The reason why we've conceded...
Sorry, I wasn't keeping up.
I'm so sorry. It's tab 21, my lord,
Yes.
page 636.
Yes. Yep.
Internal page 49 of the transcript, line 18.
Internal page 49. Okay.
Does my lord have that?
Yeah.
Yes. And I'm reading from line 18 on page 49 in the top right-hand square. The reason why we have conceded that the pre-16th of March 2020 losses are recoverable by Stonegate is not because on the facts there are, we say, 100,000 limits that
Where are you
apply.
reading? I'm very sorry.
Not at all. It's
I'm not following where you are.
line 18, internal page 49.
Yeah, I've got it.
And this is Mr. Keeley on behalf of the Stonegate insurers, explaining why they have conceded the pre-16th of March losses without saying they're limited to 2.5 million because they were in excess of that. And they say the reason why we've conceded that the pre-16th of March 2020 losses are recoverable by Stonegate is not because on the facts we say there are 100,000 limits that apply. The reason we have conceded that is because of your lordship's decision that there is not one single occurrence with which all those losses are connected. That is the first reason. Second, as we apprehend or apprehended, Stonegate's losses in the pre-16th of March period were of the order of 3.6 or 3.8 million, less than two limits. We're not prepared to investigate the facts in that detail in order to limit it to one SBIL. It's simply not practical or sensible in the circumstances.
Well, I mean, that's obviously irrelevant. I mean, was there any evidence as to what your losses are between the 27th of February
that was
where it
going
was
to-
and the 16th of March?
Sorry to interrupt. That was going to be a matter for the stage 2 trial. They
Yeah,
would.
but I mean, there obviously was some evidence, because Mr.
Yes.
Keeley refers to it, what Stonegate's losses were. And the
Yes.
perfectly pragmatic point he's making, well, given the level of those losses wasn't really very big, there was precious little point in the insurers resisting it.
Yes.
Can you read on to the following page, 51?
I'm being asked to. Perhaps my
Yeah.
friend can indicate which passage.
Page 51, the following page 51, starting at line 20.
Over the page, 51 from line 20.
79 and 80, that's what that's in this judgment,
Yes.
is it? Because this was a hearing which everybody was involved in,
This was a hearing, everybody was involved, the consequentials hearing after
79
judgment
and
had been
80.
handed down. I'm not sure what point my learned friend is seeking to draw attention to.
I just wanted your lordship to look at it whilst it's open. I can deal with it later. It's from line 20 down to page 52, line 8.
Right, should we just read that to ourselves?
Particularly line 8.
Well, the compliment from Mr. Keeley is always a backhanded one, Mr. Newey. But I mean, that's in a sense, I'm leaving aside the flattery, that's the point, isn't it? That it logically, in the context of this policy, there has to be some, if the total value isn't a limit of liability, then you've got to find a limit of liability somewhere.
That will be our submission.
Yeah, okay, all right, thank you very much, Ms.
And what we would say is we think the true position is for the pre-16th of March period is that there is no aggregation. And if the position is in relation to the pre-16th of March loss that there are lots of distinct occurrences in the form of cases of disease, which was Mr. Keeley's original position in his skeleton, it doesn't follow that there are lots of SBILs, because for an SBIL you need not just an occurrence, but there also needs to be business interruption loss that arises from or is attributable to or in connection with a single occurrence. And that's not the position for each case of disease. The BIL suffered during that period was caused by lots of occurrences. And so we would say the SBIL definition is not satisfied. There is no aggregation.
You may not know the answer to this, just help me about this. One of the things that slightly puzzled me at page 49 is why Mr. Keeley says there that the total losses for Stonegate pre-16th of March were 3.6 or 3.8 million,
Yes.
less than two limits.
Two limits, which would have been 5 million in total. There was
Why two limits? Because
on the basis he accepted that they were not confined to one limit. His position started with, well, there were as many limits as there were cases of disease. He then moved at the hearing to there was no aggregation at all pre-16th of March, and therefore it would be recoverable without
oh, I follow.
limit.
Yes. It's a
or,
pragmatic.
or it just wasn't worth the cost of
Well,
trying
it
to
wasn't worth the
argue.
cost because it wasn't that much more than 2.5
Yeah.
million. I suspect is what they're
Yeah.
thinking.
But it does, the value in Stonegate mattered. If they'd been confined to 2.5 million, then they wouldn't have recovered the additional 1.3 million that was potentially claimable. It doesn't matter for VE, but this is still in the nature, as was the reason these trials were expedited, of a test case that will apply across the market. And there are a lot of cases that are waiting in the wings. We're awaiting the outcome of these trials and now these appeals. And so this does have financial significance. It's not just
Well,
about
it's one of
whether.
the difficulties because two of the cases are settled. I'm not sure to what extent this is really a test case. And this is a case on its own facts, and for whatever reason, we don't want to know, but for whatever reason, this case hasn't settled.
Yes.
No doubt one of the reasons why it hasn't settled is because there are differences between your clients and the other insureds, or between the insurers and the other insurers. But it's not. It's perhaps less of a test case than it would have been if we'd been dealing with 2 or 3 of them.
I appreciate that, my lord, but nonetheless, that was the basis. One of those cases only
Well,
settled
what
last
we've
week.
got here really is Mr. Keeley saying, I think this is how I read it anyway. Mr. Keeley saying, well, this is what the position we've taken in Stonegate, because it's a pragmatic one, and we can't be bothered putting it colloquially. But Mr. Doherty's right as a matter of logic and construction on the argument that he ran. So I'm not sure it helps you very much.
Well, my lord, I'm not going to push it further. I hope you understand our point. We find it surprising that the test for SBIL, which is the aggregation clause in the policy, could be satisfied in the absence of aggregation.
Yeah.
And if it said there is always aggregation, at least for the pre-16th of March period, it's not been identified by what it's aggregating around. The judge has held there were no occurrences prior to the 16th of March that weren't too remote. He's looked at all of the variables. So in circumstances where there is no aggregation, then we would say there isn't an SBIL limit. You're recovering business interruption loss up to the total value, if that's an overall limit, or if it isn't, you just recover your total loss. But that's the case. I don't want to, I hope at least you understand it, whether or not you agree with it. And we say that there is no reason why the parties could not have intended that a lower limit should apply in the case of aggregation than would apply otherwise.
The judge has not really, has he considered aggregation separately in relation to losses before the 16th of March? He simply looked at the losses over the whole period without drawing that distinction.
Yes.
And I suppose it may be that if he focused only on the earlier period, the analysis might be different. I don't know.
Yes. It may be. I mean, there is a stage 2 trial still to happen to deal with losses. So
There wasn't an argument in any of these cases, was there? That because you were all focusing on identifying the one occurrence that applied to all the losses, which is my lord's point. But nobody was saying, I don't think, I'll be corrected if I'm wrong. Well, there's one occurrence in respect of everything that happened after a certain date, but prior to that, there were no occurrences or a series of occurrences.
but
It may be that's something that will need to be grappled with at a later stage.
yes. But in the VE case, there'll always be a one SBIL point was being advanced by Allianz.
If Mr. Gove is right, there may be a completely different case that's yet to be made.
But it wasn't advanced in Stonegate. They weren't saying there's always an SBIL. As I said, the best we have is what happens at judgment, which includes that there's no aggregation at all, in which case you get your loss. You're not confined to the 2.5 million. And this does have significance beyond VE. My lord, that may be an appropriate moment.
Have you essentially finished ground 3?
I've finished ground 3. I've got one short ground left, and I can deal with that if you want to take a shorthand
right
right.
now, we have 5 minutes or so just so the transcribers.
All right.
Lords, finally, I will turn to ground 4, which is about renewals, changes and relaxations of government measures. And again, permission is needed. If I can start with identifying where the judge dealt with this and how he dealt with it.
Yeah.
It's the answer to the preliminary issue is at answer 16. So core bundle tab 14, page 236. Where the judge identifies what the single occurrences which were not too remote for the purposes of the SBIL clause and around which, subject to proof, these losses could aggregate are. You'll see there he identifies the 16th of March decision, the 20th of March instruction to close, the announcement and implementation from the 24th of September 2020 of early closing and other restrictions on restaurants, and then insofar as relevant, the bringing into force of the tiered system and the second lockdown. And he says at the bottom, there are not separate occurrences when government measures were renewed, immaterially changed or relaxed. And that is dealt with at VE, paragraph 101, page 264 of the same bundle. It's really just the last line there. On page 265, paragraph 101.
Yeah.
And if I could also go to Stonegate and Greg's, it's tab 18 of the supplemental bundle, volume 2, page 535, paragraph 192 of Stonegate. And it's essentially the last sentence there. It's about renewals during the first lockdown. And then there's a cross-reference to Greg's at paragraph 86, and that's in tab 19
Paragraph 86.
of Greg's, yes.
Correct,
Tab 19, page 592. And that's where the reasoning is contained. Just invite you to read paragraph 86.
Yeah.
So the two reasons that are given, and they're both at Greg's 86, are that the continuation of existing restrictions or trivial changes effectively continue the status quo rather than making any significant changes to it. And secondly, insofar as restrictions were relaxed, such relaxations could have been expected to reduce losses and thus could not appropriately be regarded as a unifying factor for losses. And we respectfully say that that was wrong. Firstly, because it's inconsistent with the authorities, especially those cited at Stonegate, paragraphs 82 to 86 on page 510 of the supplemental bundle, which are providing that occurrence is synonymous with an event, something which happens in at a particular time, at a particular place, and in a particular way. And also that occurrence is not the same thing as a peril. And we would submit that the judge treated the search for an occurrence as though it was the search for a peril by regarding as occurrences only those government measures that strengthened existing regulations, but not those that were a decision to renew or remove them. But we would say decisions to continue or release existing measures are just as much things that happen at a particular time, in a particular place and in a particular way as decisions to strengthen them. And what the judge has done is to treat as occurrences only those events that have the immediate effect of increasing loss. And while that makes sense in the context of covered event or peril, we say the aggregation question is different. And to give you an example, at the end of lockdown 1, in July 2020, the restrictions were relaxed. Loss continued to be suffered throughout the summer. In the case of VE, there was still loss. It was at a lower level than when everybody was fully closed, but there was still loss. Now, the judge's finding that relaxations are not a separate single occurrence means that Allianz may, and we understand will, seek to argue that the decision for lockdown 1 on, say, the 20th of March, that was the decision to close all restaurants and implemented by regulations on the 21st, aggregates loss all the way through to September 2020 on the basis that there is no separate single occurrence until the early closing restrictions in September, which is on the 24th of September, about 4 days before the policy period end. Whereas what VE would say would be that the July to September period where there's been a relaxation, a lifting of lockdown 1, that's a separate single occurrence. In that the decision or the implementation of the decision that lockdown 1 should come to an end, being a relaxation of those lockdown restrictions is itself a decision implementation, particular time, particular place, particular way. We'll see in a moment, I'm going to come to the point, it's on different evidence as well. It's the evidence at that time. It's not the time of the original imposition of the restriction. Now,
but isn't the question whether if the reasonable person in the position of the Ashered had looked at the matter in, let's say, August,
yes,
would he or she have said, well, the losses that I'm suffering are in connection with this relaxation or in connection with the original lockdown, the 16th or 20th of March? And I would have thought the answer to that is pretty clearly, you'd say it was the original lockdown. But and I follow the point.
or the cases of disease that are still there, generally, which may be producing public reaction and so on. So
Anyway, you can show us.
So we would say either there is a separate single occurrence, which is the lifting of lockdown 1, so that there is a separate limit over the summer, 2.5 million. If there is no separate single occurrence at all, then we would say there is no aggregation, which means that for the summer period, VE can recover its business interruption loss. It's back to ground 3, subject to the overall limit of total value.
That's your ground 3 point.
Yeah. So there's an interrelationship there. Is there always aggregation? But the point arises again in the summer of 2020 in the case of VE. Allianz says that in the absence of a new separate single occurrence, because there's always aggregation, then the summer losses are all going to be part of the lockdown 1 losses and the decision to impose the lockdown. And we would say that at least relaxation should be a separate single occurrence. And if not, then there should be and this is back to, as I said, the other ground, ground 3, then there is a position where there's no aggregation under the disease clause. And for this, I'm assuming that there aren't 100,000 SBILs or whatever the number of cases of disease were at that point in time, because that's not a single occurrence around which the losses aggregate. It doesn't aggregate to each case of disease. And we would say that either way, there would be recovery, either under a separate occurrence limit over the summer or under no aggregation. I said that each decision that was made was on new evidence. This is dealt with when addressing causation by the judge at paragraph 55 of the VE judgment.
Yeah.
Where the learned judge made clear that the statutory underpinning to governmental measures required there should be an imminent threat to public health, which would depend principally on the current projected incidence of the disease, not on the past cases of disease. And then under the 26th of March regulations, any restrictions or requirements imposed by those regulations had to be reviewed every 21 days, emphasising that what was an issue was the current position and the current threat. So he was dealing there with issues of causation, that further government action wasn't based on past cases, it was based on the cases at the time that the decision was made. But on that basis, there is reason to regard decisions to renew existing restrictions as a distinct occurrence, because it's an event that has a different basis, i.e. the different cases that have existed or exist at the time of that decision. This isn't a simple continuation of the original decision to impose the government restriction. It's a new decision to continue or renew on the basis of the same evidence. And then the final point we make in the skeleton is that...
Sorry, you're distinguishing there then between renewal and relaxation.
Yes, I dealt with relaxation. I'm going back to renewal. Yeah, or continuation, however it's described. I'm saying it's a new decision, particular place, time, way, based on new evidence. And it's not simply a continuing on of the original decision to impose the lockdown.
Sorry, can you just remind me what happened after 21 days? It had to be reviewed every 21 days.
Yes.
What happened at 21 day points? Did the government just say, well, we've decided to maintain the regulations? Or was there anything new passed?
I'll need to check whether there was something new promulgated. There was definitely a
Was it
review
not
at
in
that point.
There was an agreed chronology or something.
Yes.
And there may be an agreed, it may be it's a chronology was.
Yes, but look, it is in the chronology. It's a core bundle, tab 12, and you can see various ones of these reviews of the regulations at page 140,
Yeah, hang on a second.
145 and 155.
Can we just because it's in landscape, so let's have a look at it. One, sorry, page 140.
Yes, my lord, is I think the first one.
Sorry, that's the very first one.
Yes, well, and then the chronology follows through some of the examples. So 140 sets out the legislation itself.
Yeah.
As one sees at the bottom of 140, the Secretary of State must review the need for restrictions.
Yeah.
If we then turn to page 145, we see another provision in terms of the 26th of March regulation again.
Yeah.
At the top 140 must review. Page 155.
16th of April.
There's a reference there to the regulations having been reviewed and continued.
Sorry,
I'm sorry, well, the last one's 155.
155.
Yes. I'm not sure I've captured all of them, but they were just some examples of the regulations being both made by reference to review.
The third review.
That's the third. The review.
How do these regulations work? Are they regulations which will apply indefinitely until there is a decision to stop them with provision for periodic reviews, or are they regulations which apply for a specified period and then have to be positively renewed?
Lord, I think on these initial ones, they continued as long as they were reviewed.
Yeah.
I think there were some later ones after our policy period, which did have some set clauses.
I think it's 6 months.
Yes. Well, actually, it's page 147, isn't it?
Yeah.
The 16th of April ones were reviewed. Actually, this is the time when Mr. Johnson was in hospital, so it was Dominic Raab. And I do now remember this. He said they remain in force for at least another 3 weeks, so again for another 21 days.
I'm corrected that they all had a final expiry of 6 months, requiring a renewal as opposed to review.
Yes.
But there are later ones, which actually only, I think, after the second lockdown, which had a 28-day expiry. Your Lordships will recall Parliament started becoming increasingly concerned about the need for this legislation, so the rules became stricter.
Thank you. Yes, sorry. Okay.
Not at all. And we can see from the review, I think it was the third review on page 155, there's reference there to the written statement of Mr. Hancock stating taking into account scientific advice and the government's assessment against the 5 conditions required for change, we can proceed with some limited and cautious amendments to the regulations to ease the restrictions as announced. And then there's a list of restrictions coming into effect. So it's being reviewed on the basis of the scientific evidence and data at the point in time. But we-
Structurally, put together what the two of you have said. You've got regulations made at the start
Yes.
with a sunset period of 6 months. And what Mr. Hancock is saying here is that there are going to be modifications which ease those regulations. So you keep the same regulations, but you amend them to introduce relaxations.
Yes. Subject to one qualification, which is if you look at paragraph page 141, which sets out the regulation 2, section 7, 227 I think it is. As soon as the Secretary of State considers that the restrictions set out in this regulation are no longer necessary to prevent, protect against, control, etc., public health response, the Secretary of State must publish a direction terminating the relevant period. So they didn't just have to go for 6 months subject to review. There was also a duty to publish a termination direction if
And the relevant period is the 6 months that's been mentioned, is it?
terminating the relevant period. I think the relevant period was the 6-month period, yes. And then there were further regulations for further lockdowns.
So the picture that emerges is that the initial regulations are the 20th of March, or I think it's, I think they counted it from the 26th of March actually. So
26th
the
of
review
March,
was,
generically.
the first review was the 16th of April,
Yes.
the second one was the 7th of May, the third one was the 28th of May. And at the 28th of May one, the carrot was dangled of coming out of restrictions as it transpired in July.
Yes. Yes.
But
And then
then,
we moved it
and then in July, there's a relaxation of the restrictions.
Yes.
So the same restrictions remained in force from the 26th of March until I think it's the 4th of July.
Yes, subject to some changes being made in the end of May.
But nothing that was relevant for present purposes. Because the
Um,
premises had to
no.
remain closed.
Yes, but I'm distinguishing between the ultimate relaxation where lockdown 1 gets lifted
Yeah, understood,
and the continuation. But there were a number of continuations, all based on fresh evidence at the time of the review. And then just one final point, which is really answering a point made by Allianz, who rely on Silversea, to say that if you have effectively the same situation, that of itself is not going to be a new single occurrence. And I just wanted to identify for you that the judge, I talked about how Silversea was different in the Stonegate case. It's tab 18 of the supplemental bundle volume 2 and 534, it's paragraph 187,
So which judgments?
Stonegate judgment, my lord, 187. It states there the Silversea case, yeah.
The critical point there was that those State Department advisories all as it were fed back to the original
Exactly.
9/11, and that's why he says they're repeated but consistent warnings.
That's right. So they were in response to that single event, whereas in the present case, we have a number of measures of increasing severity being taken in response to the evolving situation of the pandemic. And they were matters that had individual importance in their own right, that the specific advisories in the Silversea case would not. And so we say that authority therefore doesn't assist in relation to the government measures we rely on here. And then final point before I conclude is that I just wanted to go back to a brief explanation of the significance of the appeal grounds, appreciating that there were originally 3 appeals being heard and now there is 1. Allianz has paid only one limit of 2.5 million to every policyholder, leaving aside increased cost of working and claims preparation
Yeah, yeah.
costs. Regardless of the actual loss claimed, VE is quite a modest claim. There are other much larger claims out there. Now that's why its aggregation ground matters, because the only way that stance of a single limit is sustainable is to go back to Wuhan to find a single occurrence around which all of the UK policyholder losses aggregate. You already have the point about the significance of the enforced closure POA during the period of insurance point, because that is seeking to cut off the loss at the end of the period of insurance, or with the now qualification that some of that loss post that period may still be recoverable, as we've discussed the practical problems that quantifying that would cause. But for some policyholders, I mean, with VE, it affects the early closing restriction, which continues after the policy period end. It affects some of the prevention of access restrictions that were in place that continue after the policy end, like the international travel restrictions. Other policy holders have got different periods of insurance. So Greg's was the end of November. So that would bring in lockdown 2, and there may be others that would bring in lockdown 3. So again, something that has wider market importance, which is no doubt the reason it's the subject of an appeal. Our per premises, per insured location aggregation, as you know, would give us the 10 limits for its 10 insured locations. Now, their only limits and its claimable loss would be obviously what it could prove at each location had been suffered as caused by a covered event. But again, that will be relevant to other policyholders who have multiple as opposed to single locations. The always one SBIL point we say has significance to the pre-16th of March 2020 period. Unlikely to affect VE financially because its losses are unlikely to exceed a single £2.5 million limit. But Stonegate's losses were more, other policyholders' losses will be more. And as I've said, it potentially also impacts on the summer period as to whether there is aggregation or not in that summer period between July and September. And again, that's a significant financial period, both for VE and for others. And then the renewals point will affect the number of SBILs for lockdown 1, for example. Is there one or are there more? And the relaxations point will, for VE, affect the summer period. Is there a new SBIL for that period? Assuming there is always an SBIL if you find that that is the case and that ground 3 fails. My lords, those are my submissions. I will obviously have a reply in due course on Mr. Doherty's response to my appeal, but unless I can assist further.
Thank you very much, Ms. Bunker. Yes.
Lord, I'll start obviously with my reply to our appeal, and if I may start with the prevention of access and forced closure arguments. This is the question of whether the scope of cover provided by the clause, and I'm not going to repeat my central arguments of construction, but I do essentially make the point that none of the points made, and in particular the points in relation to the potential difficulties, ultimately undermine what we say is the clear natural language, which is reinforced by the use of language elsewhere. I'm not going to repeat my construction submissions. We're slightly perplexed by the suggestion that we were running a new case that might be cover after the prevention of access. I'll just give your lordships the reference. We made this clear in our defence, which is in the bundle, core bundle, page 350, paragraph 28.3, in relation to enforced closure, and paragraph 32.3 in relation to prevention of access on page 351. We made clear that it might cover restart costs. And I think we made it clear in the opening as well, but there we are. I think my Lord the Chancellor raised the question of the difficulties in disentangling the losses on our construction of having a firm line in relation to the end of a cover by reference to the length, essentially the length of the prevention access or the hindrance of access or the closure. Lord, obviously as a starting point, it does give a clear cut-off to the operation of the composite peril by the word during. So you're simply having to look at the consequence of being shut or access being restricted or hindered up to a specific point, cut-off point. Thereafter, the question of disentangling losses, we would say, is ultimately a problem with all these clauses. If, for example, one is talking, in fact, as one would be in this case, at the end of the policy period, not with the premises being shut, but by reference to access being restricted because the restaurants had to shut at 10 p.m. or there were restrictions in how many people could sit together, and the nature of those groups, there is inevitably going to be a difficult disentangling of what is caused by the insured peril, the hindrance of access in that case, which is what actually would apply in this case, and other factors. So that disentangling, unfortunately, is inherent in these clauses. We'd also say, just as a matter of comparison, that this is an issue that could arise under the material damages cover as well, under clause 2.1. So, for example, if one takes damage which occurs over a period of time, both within and without the period of insurance, so, for example, fracking, which is happening in the neighbourhood, it's causing significant ongoing damage to the property over a 6-month period. At a certain point, the restaurant or the shop has to close for repairs. It is uncontroversial that the only damage that would be covered within the policy would be the damage which has occurred during the period of policy. There would be ongoing damage outside the period of policy, which may or may not be covered, depending on the nature of the insurance. In relation to the business interruption loss from the closure and having to repair this shop as a result of the damage which has occurred both within and without the period of insurance, there would equally have to be a disentangling of the losses. So the point we really make here is, yes, there may be some difficulties, but they are not unique to this situation. And they certainly do not take us anywhere close to this sort of absurd construction which would require the court to take a firm view against what we otherwise say is the natural meaning of the words used in terms of the scope of the insuring clause for enforced closure and prevention of access. Well, that's all I wanted to say in relation to enforced closure and prevention of access. Obviously, if your lordships want me to address anything else, I'm very happy to do so. Obviously, the more substantial issue is the question of aggregation. And I think my learned friend tried to suggest, or suggested, that there was a material difference in how the 3 cases had progressed on this question of the initial outbreak, as an explanation for how the judge had dealt with it in the VE case. With respect, we don't say that is not right. Your lordship can see and has seen from the judgment and the headings of the judgment that the judge was dealing with exactly the same issues in each, i.e. initial outbreak in Wuhan. And indeed we have in the bundle, we don't have the Stonegate defence in the bundle, it is the same effect in this regard, but we do have the Greg's defence, and we can see that at supplemental bundle 1, tab 9, page 202. And if your lordship sees about a third of the way down under A, one sees their initial outbreak of COVID-19 in Wuhan. This was the same pleading in each of the cases, which is why the judge dealt with them in the same way. Secondly, I think there was a suggestion that the evidence in our case might have been materially different, and I was slightly confused by that, because at one level my learned friend was relying on the Stonegate material and others saying it progressed differently. Just to be entirely clear, the question of spillovers and zoonotic leaps was evidence in the VE case as well as in the other cases, and one can see that if one goes to supplemental bundle 8, so bundle your lordship, tab 8, page 182. And can I just invite your lordship to read the paragraph starting "we discussed in detail," which is in the middle. And in the following paragraph, there's Professor Byvant believes there's a reasonable chance that lineages A and B were each created by more than one cross-species transmission event, and the further research is needed to determine if such a scenario is more or less likely than the minimum number of 2 cross-species transmissions. So you have two zoonotic events, and then at that stage, not in a position to say whether it's more or less likely that there are more than 2, but there might be. And of course, I invite the Lords perhaps just to look at some of the references that both parties have given in relation to the evidence after this, because there is a fair amount of material. And I know my learned friend took you to the summary in her skeleton, and you'll be unsurprised to know that we might suggest that it was a tendentious summary focusing on certain aspects, whereas in fact what we have the full material essentially in relation to zoonotic spillovers being deployed in this case. And indeed we have this point. I think my learned friend made the point, and that the judge expressly said that the evidence was materially the same as that in Stonegate, and the reference to that, I think your lordship was taken to it yesterday, is tab 15 of Core Bundle, page 263, paragraph 91. So, and it's also right to say, again, I think there may have been some suggestion the position might be different, but just to be clear, that the judge did not make a declaration that initial outbreak was sufficient in any of the cases. What there was a slightly different approach. Just for your lordship's information, in Stonegate, the appeal was progressed on the basis the judge had found the initial human infections, and the argument that that wasn't sufficient was progressed by a respondent's notice. The argument wasn't essentially the pleading point that the judge hasn't found for you. It was essentially a different point where the judge shouldn't have found initial spillovers as being an occurrence. In this case, we have the different position whereby my learned friend doesn't seek to challenge the judge's findings that the initial zoonotic spillovers could be treated as an occurrence, but does seek to take essentially a pleading point to say, well, I think as my Lord Justice Mail said, you've had 17 shots, but you've not managed to obliterate the target. And in my submission, it does show an air of unreality, if I may say so, that clearly when one is looking at an area where you can express something in multiple different ways, as indeed the pleadings show, and as multiple different parties have taken the approach in the Greggs and in Stonegate, to say that a small variation in how it's put should somehow be determinative. And we certainly say that that's not the right approach. And indeed, my learned friend was very right to say, when she said, well, the real issue here is about remoteness and the approach to remoteness and whether the judge was right. We would say that's right. The short answer, we say, is, the initial question is, was the judge right to say that initial outbreak was not apt to include those initial human infections and the initial zoonotic leaks? And we say, no, the judge with respect was not right. He should have accepted, as effectively he did in his reasoning, that the narrower way of encompassing initial outbreak would be to look at those initial human infections. And so he should have concluded that there was an initial outbreak, albeit qualified by reference to the very beginning, those initial human infections. My learned friend suggested that we were putting forward essentially a unifying factor based on originating cause. The answer is, of course, we're not. That's why we've gone to all the effort of identifying events. Now, as I indicated in my submissions yesterday, they may lead to the same thing. as Lord Justice Wallace said in the W.E. Brown case, they're not necessarily different. The approach is different for what you're searching. You may get to the same answer. And in my submission, in a case where the judge here has accepted that there was a single occurrence, albeit not how we expressed it, that initial question effectively is answered. The judge has found that there was a relevant single occurrence. The issue is simply whether it was too remote. Now, before I go back, turn to remoteness specifically, can I just deal with the alternative events that we put forward? And I won't spend much time on this because Your Lordship will have seen that our main focus is on those initial infections, which the judge found was enough, and saying that is enough for an initial outbreak, and the judge should have found so. But we do put forward the first human-to-human transmissions as an alternative. Now, my learned friend said, well, that's not right, because they might or might not have existed. I think she posited the example, well, what if someone sneezed at the same time and everyone got it at the same time? There would in fact really be a single occurrence at all in that sort of situation. But Lords, it was agreed that there must have been a first occurrence in this case. And my Lord, if we go back to the joint statement, which is on the supplemental bundle, tab 8, page 181, under D, the first human-to-human transmission to have actually occurred, by definition, such an event must have existed. And then they say, but we agree it's highly unlikely to be the same as the first reported case. And then there's a reference about the timing, which we don't need to go. But this positing that, well, there might not even be a first case, well, in my submission, that is going too far. There it's my learned friend going beyond the evidence. Now, of course, that's a separate question, and I accept it is, from both whether there is a causal link and from whether that is a, in my language, meaningful, significant event. But in terms of a single occurrence, in my submission, that point, insofar as my learned friend suggests there isn't one, it is a bad one. Now, Lords, in relation to the causal link of the first case, and let me just focus on the first relevant case to simplify matters for the purpose of today, that is to say, the first case to give rise to sustained community transition, which did not die out. In my submission, the judge was plainly right and plainly entitled to find that that was sufficient to meet the weak causal link. The judge expressly accepted this, and in my submission, he was entirely entitled to do so on the evidence. So really, in my submission, the question isn't about those aspects. It comes back to the core, which is, well, were those events too remote with whatever qualification one needs? Lord, in relation to the first case in the UK, the introduction question, which is the fallback that we have if Wuhan is not to be regarded as providing the relevant event. My learned friend sought to draw a distinction between how we argued the case and how it was argued by Mr. Keeley in Stonegate. Now, that may have made it sound like more of a distinction than it was. What my learned friend, Mr. Keeley, was arguing in the Stonegate case for insurers was that every single case in the UK, in light of the Supreme Court's reasoning, was connected with the subsequent losses. And it wasn't necessary to choose between them. And indeed, you'd aggregate to the first one. And so that was based on the Supreme Court's reasoning that, you know, if each and every case is a proximate cause, then a fortiori that it has to satisfy the causal link.
So that was an argument, was it, that every single case from wherever the first case of human transmission in the UK was, let's say it was the 31st of January, we saw them certainly before that, but everything thereafter was all one occurrence.
Yes, and the argument is at tab 18 of supplemental bundle, the Stonegate judgment, paragraph 135, which is page 523.
Paragraph 135.
100, starting at 135, yes.
Yeah, okay.
And Lord, it's there. I mean, it's not the argument we make, but our argument, in fact, is a more limited version of that. The distinction between the argument that Mr. Keeley was putting and the arguments that Allianz was putting was that our submissions were focused on identifying a case which had particular meaning, particular relevance. And that's why we said that the case with particular meaning in that context is the initial introduction, the first case. Why? Because that is what's associated with coming to these shores. So we were seeking to answer in a way the question that we pose later on, with is it a meaningful or relevant question, which arguably it might be said that the way that it was put by Stonegate insurers left open the answer which the judge gave, which was to say, well, none of these are particularly meaningful. Even if they do satisfy it, they don't provide any useful meaning. And that is why we focused on the beginning, to say, well, they does provide meaning because it's the beginning of the story in terms of the coming to the shore and the effects, therefore, on public perception and government reaction. So well, that's the distinction that was between the parties. My learned friend also sought to dismiss the Simmons and Gamble case, where your lordships recall that's the case, one of the 9/11 cases, the judgment of Mr. Justice Cook relating to the Port of New York. And if your lordships want it up, it's Authority Bundles 2, tab 24. And my learned friend said, well, it's not much of a persistence because, well, there was no other cause other than 9/11, and remoteness wasn't an issue. Now, my lord, before I make my very short submission on this, let me be clear. This is an illustration of the point that we say illustrates how the application of meaning and how an important event can continue to define a circumstance, even though there are intervening events. It is no more than that. But it is in my submission wrong for my learned friend to suggest that the issue of remoteness, etc., was not there. That the key complaint in the case was that causation was too weak, because one can see from paragraph 7 of the judgment, page 755. That this related to events in the hours, days, weeks, months, and possibly years following the attacks on the clear-up operation by the Port of New York. And in paragraph 8, one can see that there are two sets of claims. They're the workers' compensation claims by workers who were at the site at the time of the attacks. And then there are the respiratory claims, which are obviously the more ongoing ones, under 8.2 in relation to the continuing element. And one can see at paragraph 12 what reinsurers had been arguing, which was that it was necessary to identify event, and that the Port of New York's failure to provide adequate protective equipment to 10,000 workers over the cleanup did not constitute one event, and that the respiratory claims arose from a continuing failure to make available the protection, etc. And for the purpose of the aggregation clause, the attacks were too remote to constitute an event. And the judge, Mr. Justice Cook, went through all the causation cases and remoteness cases, paragraphs 21 to 26. And one can see that the argument, his answer to the question, obviously this is in the context of not interfering with the arbitrator's decision, but in paragraph 29 is where he sets out his guidance in relation to the unities and saying it's not a straitjacket, so it's a useful section. But paragraph 30, once an event has been identified which is not simply a state of affairs, such as the attack on the WTC, the only issue which mattered was the question of sufficient causal connection with the losses in question. And then going down a few lines, the arbitrators found a clear and obvious causal link between the attacks and the claims for inhalation of harmful toxic dust, even if the negligence of Pony was sufficiently causative for liability to be established. So this is a context where obviously the Port of York had in fact been liable for their own negligence, not obviously for the attacks themselves. For the purpose of reinsurance contract, there was a significant causal connection with the attack on the WCC which justified aggregation. And again, that's a factual conclusion, but in my submission, the notion of what's significant there and what the arbitrator is doing is in the context of an attack like 9/11 continuing to have the relevance for days, months, years, even though for the respiratory claims there are obviously potentially competing other arguments, such as why were people there without the proper safety equipment. And then if I can take your lordship to just paragraph 37 to finish this point off, as how the judge looked at it, it can readily be said from the perspective of Pony, the claims against it arose out of the attack on the WTC and the destruction of the Twin Towers, with the resultant debris exposure of people at the site at the time, and following the event, the harmful and toxic substances, whether or not there was any failure on their part to protect those who came to the rescue to the site. So, my lord, we do say it does provide some useful illustration. Now, my lord, turning to this case, we do say that the striking fact is that when one looks at what the judge did at paragraphs 152 to 155 of Stonegate, which is where he considers remoteness, there is no standing back, as Scott and Copenhagen suggests, and Lord Justice Rick suggests one should do it at paragraph 81. There's no exercise of judgment on a global and intuitive basis, or asking if the event, notwithstanding the issues of time, geography, and the additional causal steps, might still be the most relevant or meaningful explanation. Of course, I accept you can ask all those questions and still come to the conclusion, no, that it isn't. But that's the error. The error is that if you have a test which necessarily requires an exercise of judgment, that aspect of it needs to be made explicit as to what one is weighing up. Because if one pulls it back, one has the three stages of the analytical side, leaving aside the global intuition aspect. One has the identifying of an event, well, the judge has done that. One has the causal link, it's a wide causal link, which the judge said was satisfied, certainly in relation to the initial infections. And then you have the question of, is it too remote? But is it too remote must be asked by reference to what the other options are and the perspective of the policyholder at the time. And in that situation, one has a policyholder who's beginning to suffer losses before the 16th of March, before the government has done anything. You've got the fact that government action is merely a response or a mitigation, and it's not a single action. And importantly, that there would have been losses in any event. Not exactly the same losses, I accept that. But the Sweden example is intuitive, is useful in that way, because this is not a case of saying, well, actually something that was done by government has overwhelmed or overtaken the relevance of the original event which the judge has identified. It is simply a natural consequence. And I do come back to this point that I made yesterday, which in my submission my own friend didn't tackle, which is that one is looking at this by reference to the time at which the aggregation takes place. was not looking at it prospectively from the time of the event, but retrospectively. That's the perspective of the policyholder. So all those, well, what if other things might have happened? The answer is, well, from the perspective of the policyholder, looking at it at the time of aggregation is, it didn't. And if it were a situation where one would say, well, there were material changes that occurred as between that vantage point of the policyholder taking the view and the original event that we rely on, well, that would obviously be a much more powerful aspect. But we say what one saw in the UK, as in most countries, obviously not all countries, was the natural mitigation and response of government, which was simply a symptom of the original event rather than the meaningful explanation for what was occurring. So we do say that the error of the judge was essentially to do what my learned friend suggested that he was entitled to do, which was to look at the three analytical tools. I think my learned friend said this explicitly. If it doesn't satisfy those tools, you never get to the intuitive judgment. You don't need to do that overall exercise of judgment. And I think it was explicitly, and it's in my learned friend's skeleton as well, as part of the introduction to this topic. And we say, well, that is simply contrary to Scotland and Copenhagen, because that does invite the overall view and makes clear that you're looking at it both ways. And it also invites an overly analytical approach to the three aspects, because the remoteness is merely a tool to help you select. But if you have two candidates, it's easy if you don't have any other candidates, but if you have 2 or 3 candidates, how do you choose between them? Time, geography may be factors. I don't suggest that they're never going to be factors, but we come back to the point that it's the significance, whether it's the Mount Tambora example, 9/11, and as we say in this case, the emergence of the virus, that will often provide the answer to what it is one should be focusing on.
The difficulty, which in a sense the judge faced in these cases, is that it's a point that I touched on yesterday, that in many of these aggregation cases, there's only one candidate. And if it was either that Mr. Outhwaite's negligence on 32 occasions, one originating cause, or what it was, or there wasn't any aggregation, you just had 32 claims. Here you've got, on your case, competing candidates to be the occurrence or event. And on the judge's findings, at least one of the earlier candidates that you rely on, he has found satisfies one occurrence. So how are you going to decide which one it is? I mean, you would say presumably, well, there were 2, one after another. But I mean, does the government policy take over at some point?
It can do. And also, I mean, your lordship's asked, if I may say the exact...
You see, the reason why I pose the question, and I'm not suggesting your submissions about this are wrong, but that's why the judge focuses on remoteness, because he's looking for a way of saying, well, using Lady Justice Andrews' words, I'm looking for a meaningful explanation, and this is a meaningful explanation rather than something else which is too remote.
Well, Lord, the judge didn't, with respect, directly do that. And I appreciate your lordship could say, well, that is what he was effectively doing. But what is missing from the judge's analysis is anything which shows a stepping back from what one might say the strict causal elements. And your lordship, if I may say so, asked exactly the right question, which is, well, how do you choose between them? And I don't at all shy away from the fact that remoteness is part of that analysis, and therefore the judge was perfectly entitled to consider geography. We say it wasn't very relevant in this case, perfectly entitled to consider time, wasn't very relevant, very short in this case. Causation is slightly different, because in causation, he didn't have a free hand with respect on causation to say, actually it was too weak a connection, because the selecting clause had already made that express decision that aggregation could be by reference to weak causal link. So merely saying, weak causal link couldn't be enough. But, so the question then becomes, well, fine, but that doesn't, if that still leaves potentially a number of candidates, what's the approach? And that's where, whether it's highly relevant, whether it's most relevant, whether it's significant, whether it's meaningful, I'm agnostic as to the terms, the court needs to do that value judgment. In some cases it will be very easy, and perhaps the 9/11 examples are the easiest examples of, you know, perhaps in a slightly different context, but the language of Mr. Justice Tomlinson of defining event. One couldn't really argue with that as the defining event. I appreciate that this doesn't have the same defining event extent of a 9/11, but it does have a very firm beginning because one is talking about a novel virus which simply did not exist before, which came out and which actually from very early on the world was watching. And so this is a very unusual case. And in answer to your Lordship's question of, well, how long does it aggregate for? Well, the question is, as long as it satisfies the causal test, and at some point it won't, and beyond that, continues to provide the most meaningful explanation. Because I accept that there may come a point, and the one I posited yesterday was the point of time at which there is the disease has gone into abeyance and then re-emerges. One can see, well, the re-emergence is no longer really sufficiently connected.
So the second lockdown, for example.
Well,
I mean, if we were dealing with a policy where the second lockdown mattered, which I don't think we are.
Well, I don't think I have instructions to make any such concession. But one can see. One can.
But you follow the point.
Well, of course I do. One can see the argument that there will be a point of time at which it is no longer the meaningful explanation. I'm obviously arguing this case in relation to the specific facts, and here the policy period comes in before what's normally regarded as the second wave. I know that people were seeing it at the end of September, but it was certainly before the second lockdown. So in my submission, this case is a relatively straightforward one. I certainly accept that there will come a time where that happens, and of course these are one-year policies, so it'll never go beyond that. But it is, and it's an answer to your Lordship's question yesterday, where I know your Lordship wasn't saying it was the same as effective cause, but what did meaningful mean? And it is an attempt to provide an explanation to select between the options. And your Lordship's right, that's why this case is different from other cases, because most other cases haven't had to grapple with this choice question. And if you're going to grapple with a choice, you have to have the language to grapple with that choice. What are you using? One could just go back to what Lord Justice Rick says and the intuitive overall judgment, and that is obviously one option. But in my submission, it is helpful to go beyond that and to use the language put in to the legal lexicon by Lady Justice Andrews of meaningful explanation or an equivalent language to help with that process.
So at the stage of causation, you may come up with a number of occurrences which have a sufficient causal connection because in this case it only needs to be a weak connection, although some of them may have a strong causal connection or may even happen to satisfy the requirement of proximate cause. But then that simply gives you your list of candidates, is that right? And then you ask your most significant, most relevant, most meaningful, all those meaning much the same thing, question, to find out which is the relevant aggregating event. Is that how it works?
Yes.
And if you do happen in your list of candidates to come up with something which is in fact the proximate cause, it's not necessarily quite the same question, but it is likely, is it not, in most cases, that will give you your answer to the remoteness question.
Well, that was going to be what I said in relation to my Lord the Chancellor's comments yesterday. Is this close to effective cause? And the answer is, of course, it is accepted generally, and I suppose it must be right, that when one's looking at an aggregating event, one's not looking at the proximate cause, because effectively then one's depriving aggregation of much benefit in most cases. And in a way, that answer is already telling you that causation is not king. It's a factor, and clearly if you are too far back, it's no longer going to provide a meaningful explanation. But it is no more than that. That there is a danger if one looks at simply cause and connection that you end up with being the immediate cause, the last cause, and then you end up with positions a bit like the Simmons and Gamble case, where you could say the immediate cause of workers being sent in to work without respiratory equipment is the negligence of their employers in not giving them the proper equipment. But again, the intuitive common sense answer, which the arbitrators found and which the court upheld, which is consistent with the principles, is to say, well, no, it's this is the key event, has a causal link, and it's a proper explanation. In a way, one is simply putting the candidates up against each other. And of course, if your lordships put the candidates up against each other and conclude, well, it's all very well, these submissions, but the reality is we still think the government is by far the most meaningful explanation for it, well, then I've lost. I accept that there's a judgment to be made at the end, and if your lordships conclude that the most meaningful is that aspect, well, then that's the answer. But what the judge hasn't carried out that process. The most that can be said is he must have had it in mind. Well, with respect, it's a detailed and careful judgment, and he doesn't split that aspect out at all, even though all the cases are clear that it is an intuitive and overall judgment, as well as simply an analytical analysis. That's really our point.
Well, he cites Scotland, Copenhagen, Re, and then he deals with, at least in this judgment, in a rather truncated way. I mean, I follow your point about that.
Yes. No, he cites the passages, because obviously the parties cite them in the legal section, but in terms of the application of it, does he actually do the exercise that he said? In my submission, he simply doesn't. And it's more than just saying, well, he should have cross-referred and said, is that also intuitively my view? Yeah. It's actually the analysis of saying, and looking at this event by reference to the other potential candidates, is it more or less meaningful, and why? And my submissions about mitigation and were the same in front of the judge. I made this point about why government action wasn't the most meaningful. I mean, ironically, government aggregation was the fallback for all the parties before the judge, because obviously my learned friend was saying no aggregation, and in fact all the insurers were trying to either go back to Wuhan or UK, and the government was somewhere in between. No one was arguing, in fact, for that being the best explanation, but it doesn't prevent it being the answer. But it's not the analysis the judge did, and we say when one does do the analysis, one is pushed back to the original explanation, the development or the emergence of this virus, which continued to be potent at the relevant time.
Well, unless you said, going back to the point I was putting to you a moment ago, well, up until the 16th of March, there was an occurrence, whether it was Wuhan or first transmission in the UK or whatever, which is sufficiently causative of the losses up to the 16th of March, then government action on the 16th of March is a fresh occurrence. So you've now got two occurrences. But that was never actually argued.
And I'd have to go back to the pleading as to whether it was open. It certainly wasn't the focus of the argument, in the sense that the focus is very much...
The point you just made, really, and very frankly, you said, well, actually the government... the 16th of March was not your favoured position for obvious reasons, because you wanted to aggregate everything as one occurrence, including the losses prior to that date. But I can see so the judge hasn't actually made a finding, because he wasn't invited to, about what the position was prior to the 16th of March.
Yes. Well, I think that's right. And it may be, and I don't have the numbers in front of me, but it may be that in this case it doesn't make much difference in terms of what the numbers are. Maybe for some businesses it does have a much more significant impact. And I heard what your lordship's comments to my learned friend in relation to this not being a test case, and of course it is not formally a test case. But it is right, obviously, that it does have a wider implications for others. And so I suppose what I would simply invite your lordships to be aware that in that sense, and it's partly an answer to my learned friend's pleading type point, that a useful answer it may include points that are not directly relevant to this case. So, for example, if your lordships conclude, even if it makes no difference to this case, that it should have been approached in a different way, that may still be helpful more widely. But I put it no higher than
Well,
that.
the difficulty, I follow that, although it's fair to say that in this court we're very reluctant to engage in that sort of exercise, because it's effectively a hostage to fortune in relation to other cases. But it may be that if this point about losses between, let's say, the middle of January and the 16th of March was a sufficiently significant point in another case, it might be argued in a different way, and the argument about there being more than one occurrence might actually expressly argued before the court in a way in which it hasn't been in the present case.
Yes, Lord, and I accept that. I suppose what my submission was almost making that clear, that insofar as there is a nuance which is relevant for other cases, perhaps it's important that is clear, because it is right. The focus on this case is, Wuhan. The reason your lordship has our submissions as to why we say what happened on the 16th and 20th doesn't actually change matters. It remains connected with. But of course, I accept that another of the multiple conclusions one can reach would be to split up aggregation in the way your lordship suggests. So, I mean, one of the difficulties with aggregation is, of course, that there are really I won't say infinite, but a very large number of potential candidates, and your lordship has already heard submissions on there being 18. Your lordship perhaps may not be surprised that there were even more candidates at one stage being mooted. It just illustrates the difficulty.
The structure of the judgment here is that he goes through the candidates one by one, and at an earlier stage of the judgment, he rejects the initial outbreak, or the Wuhan way of putting the case, on remoteness grounds, before he even gets to government action.
Yes.
So your complaint, I suppose, is that having found that there were, you would say, he found that there were 2 single occurrences, he never actually does the comparative exercise, because he's already rejecting Wuhan before he starts talking about government action.
Quite, my lord. It is necessary, if we're right that most relevant significance is a touchstone for selecting, then one does need to do, we say, that comparison. And it might be said against me, well, it's implicit. But in my submission, it's a carefully crafted judgment, and that is not an exercise which he is purporting to carry out.
No.
I'm conscious of the time. I've finished my submissions in reply, and I just need to do.
So you finished your appeal?
I finished, exactly. My appeal is now.
In that case, we'll break 2 o'clock.
All right.